everyone to another one of Australian Business Lawyers and Advisors webinar series. Today we're talking about managing injured workers in a post-pandemic world. It's great to have you here. My name's Kate Thomson. I'm a Senior Associate in our Newcastle office, and with me today I have Julian Arndt, who's an Associate Director in our Sydney office. Welcome, Jules.
Hi, Kate. It's great to be here. Sorry to all the Kyle Scott fans out there. Kyle took the very meta approach to be ill for the ill and injured workers webinar, but you have me and we'll have a great time.
That's right, and we're all glad he's not here with a runny nose on screen. So today, Julian, we're going to be talking about, I suppose, some background and scene setting stuff to start off with, a bit of a legal introduction to workers' comp claims, just as a bit of a refresher. Important to note, I think, as well, and we'll come back to this during the course of the presentation, nothing's really changed from a legal perspective. Everything's changed, but nothing's changed to some extent when we're talking about managing ill and injured workers. We'll talk a little bit about non-work related illnesses and injuries because many of the principles are the same, regardless of whether we're talking about workers' compensation or non-work related illnesses and injuries. Before we finish up, we'll talk about some case examples just very briefly to give a little bit of background and colour to some of the things that we talk about during the course of the presentation. And then finally, we'll talk about some practical steps. So we'll tell you everything that's wrong, and then we'll end up by hopefully giving you some things to think about and move forward with in your workplaces. So I think, it goes without saying, but I'll say it anyway. The pandemic has been a period of unprecedented change and challenge for employers, and it has had a significant impact on how businesses perform work, how their employees come to work, and the fabric of the work-home dynamic as well. And the reality of that, Julian, is that remote and hybrid working arrangements are here to stay.
We've changed the way we live our lives, and that means work's different, our relationship with our employer is different, certainly employers' relationships with their employees are different. We will talk about the same old story in terms of managing ill and injured workers and the same laws applying and those kind of things, but it's just not the case to say that nothing has changed in terms of the practical application of those laws in the brave new world of post-COVID or current COVID or whatever this is.
I think we'd hoped we would be talking about a post-pandemic world at this juncture, but unfortunately we're not. So I think the reality is, though, remote hybrid working arrangements, flexible work, whatever you want to call it, and however it works in your particular workplace is here to stay. So what do we actually need to think about when we're thinking about those same old issues in their new incarnation? So like you said, Julian, the law hasn't changed significantly, but the pandemic has brought a couple of issues to light or to the fore. Firstly, we're facing a mental health storm, whether that's non-work related psychological injuries and illnesses or those work-related psychological injuries and illnesses that I know, and I'm sure you do, many of our clients are struggling with at the moment. And as a counter to that, or as an addition, the continued blurring of work and home life. So how do we, how does all of that play out? What implications does that have for us? Well, there's two main issues, I think. Firstly, ensuring that employees are well and able to come to work safely and healthily. And then also, what do we do when things go bad and we have to manage the situation?
On the mental health issue, I mean, as my grandfather always used to tell me, you are not a doctor. I'm not a doctor, nor are you, Kate, and it's very likely that many of the viewers today watching aren't doctors either. Mental health is really, really difficult to manage as an employer because it is not like a broken leg. It is not like a cut to the arm. It's not like a missing finger. It is something that needs to be handled by professionals, as all medical issues need to be handled, but it doesn't quite have the same outcomes. It's harder to manage. It's harder to see. It's harder to smell, taste, all those kind of things. And so, the nature of the pandemic, the nature of modern life, increasing awareness of mental health issues, meaning mental health claims are going to increase and increase and increase and increase and increase. You mix that in with a blurred line between work and home, and you've got a very distinctive problem in terms of managing ill and injured workers on behalf of employers.
So let's talk a little bit about that perfect storm before we move on to talk about our fundamentals, our legal principles. So the CEO of iCare New South Wales recently came out and said mental health is going to become the single greatest workplace issue facing employers and employees over the coming years. And we're seeing roughly about that 13 to 17% year-on-year growth in the number of psychological injury claims through the workers' compensation system. So, I mean, that's a very significant growth if it's continuing to be consistent year on year. So what does that mean, Julian? What's the outcome there, and what does that, I suppose, mean for our, managing employees, hopefully recovering them back to work?
Well, it means that there's a greater workload on people who are in business trying to manage injury claims. There's also a whole different world opening up for people who are in businesses which may not necessarily have had your traditional workplace injuries. The more clerical type of environments where you might have had, well, a lot of our workplace injuries are RSI related or occasional workplace stress claims. This is becoming much more prevalent. Again, you throw in the working from home aspect, the fact that everyone, to be fair, has had on their head on a swivel for the last 3 years, just trying to deal with the disasters of the world as they come thick and fast. A lot of these things now have been left unchecked, have been left unmonitored, and we will see an increase in claims, and that makes people's lives more difficult.
That's right. And the reality is when we're talking about psychological injuries and as compared to physical injuries, as you drew that comparison a moment ago, we're talking about a situation where employees are much less likely to come back to work within a 6-month period of time. So you can see there on the slides, we've got a 90% return rate for people who sustain physical injuries in the workplace versus a 50% return rate for people who have psychological injuries arising from the workplace. And the reality of that, unfortunately, is the longer someone is absent from the workplace, the less likely they are to come back to work ever, if at all. That's right.
The stats on this are quite extraordinary in terms of if you spend over 6 months out of the workplace, it's not that you're very low likelihood of ever coming back to that workplace. It's that you have a very low likelihood of ever coming back to any workplace. The thing that jumps out at me from that slide, Kate, is that psychological injuries traditionally, in the bad old days, and maybe we've left them, maybe we haven't, psychological injuries are the type of injuries which some parts of employer businesses might look at slightly more skeptically. Oh, he said he's stressed. Is he really stressed? Or he says he's anxious. Is he really anxious? These are real things. Again, I am not a doctor. You may not be a doctor either. The result of psychological injuries is actually worse. I mean, you're actually out of the workplace for a longer period of time. And as you say, if you're out for long enough, your chance of ever returning to work diminishes exponentially.
That's right. And also just from a practical perspective, there's claims implications or premium implications the longer someone is absent from work. So that brings us to our next section of slides, which is really just a bit of a refresher on our principles of workers' compensation claims and the various schemes. We will give the get out of jail free card here, which is that this does depend on the jurisdiction that you're in. So please do check your state or territory legislation. But the general principles are largely the same. Our first is that there must be an injury, Julian.
That's right.
So either physical or psychological. Let's give injury kind of a broad construct when we're thinking about some of these themes, because it can be everything from, as you said, things like anxiety through to, our traditional cuts, lacerations, abrasions, right through to, very serious physical injuries as well.
And what do we want to see as employment lawyers? We want to see evidence, medical evidence of the injury. So it's not going to be enough for the employee merely to assert that they've been injured. Equally, it will not be enough for an employer merely to say, oh, no, that's not a real thing.
I don't believe you.
Exactly.
That's right. Okay, so we've got the injury. which is supported by appropriate evidence, as Julian has pointed out. The second thing that must be established is that it actually occurred in the course of employment. This can sometimes be a really complex part of the factual matrix, Jules, because I think, it's often the case that there's no dispute that there is some kind of injury or illness in existence, but it's a real question, particularly when we come to psychological injuries, as to whether or not the workplace has actually played a role in that person becoming unwell in that way.
That's right. I mean, it can also be a question in terms of your traditional physical injuries, whether someone has actually injured their back lifting up a box, or whether they injured their back playing basketball.
That's
or something
right,
along those lines. So that's part of it. Number three, the employment must be a substantial and contributing factor, which kind of blends into two, doesn't it?
That's right. So we need it not only to have arisen out of the employment, but also for the employment to have that sort of factual contributing matrix at play to actually end up with a claim, and then end up with a claim which is actually accepted by the insurer or the agent. So I think you've alluded to this first point here already, Julian, but I think it's important to say from the outset, most workers' comp claims are legitimate, but the reality is some are fraudulent or otherwise exaggerated. And if you as an employer receive a claim about which you have suspicions, our advice is always an active and early response is the best way you can properly interrogate the claim and hopefully have some kind of influence on the outcome and its claims handling procedures from your insurer or claims agent's perspective. I think the important thing to remember, and this is a theme that we'll come back to later on in the presentation as well, Julian, you can't rely on someone else to do some of the legwork for you. Everyone has a role to play and everyone has their own job that they need to do, but the employer does also have an important and key role to play in these early stages.
The other sort of lens I'd put on this is, particularly when people like us give presentations like this, a lot of what we're talking about is how to protect the employer side of things.
Yep.
How, we've mentioned the prospect, the possibility, the existence of some fraudulent or otherwise exaggerated claims. Nothing should take away from the fact that all employers have work health and safety responsibilities. Employees should be safe in the workplace. Employers have obligations on them to make things safe for their employees. And my vast experience of this issue is that employers actually do want to keep their employees safe. So I like to add that in when we're talking about ill and injured workers, because it's not the case that this is a subject where employers in the main are seeking, well, how can we just lower our premiums, or how can we interrogate a particular injury claim? It's actually not how it usually plays out. For the vast majority of cases, it's a question of we did the best thing we possibly could do to try and make the workplace safe. Workplaces can be dangerous. Injuries can happen. Everyone knows that. This is really about what happens when an injury does occur and what you should be doing. And as Kate says, it's on you. Be proactive, engage in the process. The process can be complicated, but the process will not work. And we'll come back to this point time and time again. The process doesn't work if people just sit back and do nothing.
That's right. So I think the first thing I often suggest to people if they're coming to us for some advice and support, if they do have a workers' compensation claim, have you actually conducted your own investigation or inquiries into it? And I think this is a really important step to take, particularly if you knew nothing about anyone experiencing any difficulties, let alone the person who's made the workers' compensation claim. So it's regrettable, though all too common, that sometimes the first time you hear about bullying or harassment or other really significant workplace issues is, when you get that workers' compensation certificate across the desk. So let's step back. Have we got the info we need?
This isn't a question of, I'm impinging on someone else's jurisdiction. I mean, ultimately, the reason why a workers' compensation claim has happened is because someone has been at work and has been injured. Now, it might be a bullying claim. You should investigate bullying claims. I mean, that's 101. It might be a workplace injury. You should investigate that you've got a safe system of work such that someone else doesn't get injured. So very, very often there are concurrent investigations happening at the same time. And really, they are talking to two different things. One's is this person able to get compensation? The other one on the employer side is usually, do we need to fix something? Do we need to make the system of work, the place of work safe so that this doesn't happen again, if it ever happened?
That's so true, Jules. So hopefully, we've gone through that process. We've conducted our inquiries. We've spoken to relevant people if we need to. The next step is to actually make some factual findings. And I know, Julian, you're doing some training tomorrow in relation to advanced workplace investigations. And this is one of the key things we come back to time and time again when we're talking to people or coaching people through investigations, which is you actually need to come up with an answer, a factual finding. And that flows into our third dot point there, which is, let's focus on when we're considering our process, when we're considering the findings that we might need to make, what's the insurer actually going to look at? What are the key things, those three things we talked about a moment ago, that are integral to a claim either being successful or declined? And also, as you said before, Julian, of course, are we discharging our work health safety obligations generally? But in this point as well, a really important thing to consider if you do have a psychological injury claim is, okay, well, we do have a reasonable management action defence available to us. Can we actually discharge that burden?
So I smile because it is just assumed time and time again that, this only arises because because of management. And obviously we engage in reasonable management action because we've got great managers and they're great managers and they've done so well. You need to actually investigate the facts of what specifically happened. You might have a brilliant manager. They may have done over time and in every other aspect of their job a great job. For a particular management action that they undertook, you might look at it in the cold, hard light of day and think, actually, no, we've got a problem here and we're not going to be able to rely on reasonable management action defence, and therefore the insurer is going to, there'll be a risk that someone's going to find exactly that, and then we've got a problem. So
that's right. And then if we're sort of further down the path of the claims management process as well, but still in these sort of early stages, what's the actual medical evidence that's before the decision maker, so the insurer? Do we have sort of symptoms presented on the certificates of capacity? So those things where you see a stress or a bullying word on the section where it should say injury. Do we need to think about whether a specialist medical opinion is appropriate in the circumstances? And I know a lot of people will say, well, that's the insurance company or, claims manager needs to have responsibility for those things. But I think part of the employer's role in the process is to be a bit of the squeaky wheel. Let's look at those things. Let's see whether or not you yourself are satisfied these things exist. And if they don't, can we lobby for them to be actioned?
The other thing is, and I mentioned the prospect of two processes being undertaken before. I mean, employers have obligations in of themselves. It is usually very relevant for employers to know the medical status of their employees, their fitness for work, the risks arising for a particular employee by engaging in a system of work. It is in your interest as an employer to get the details such that you can make your own decisions, forgetting about what, independent of what the insurer might do. And I think we might touch on that point slightly later in the presentation.
I think we do. Before we kind of round out our general principles discussion, we'll just speak briefly about COVID. I think everyone is sick to death.
I think we should keep this very brief, Kate, if only because this isn't a COVID workers' compensation, ill and injured presentation. There are plenty of those, believe it or not, out there. But give us the COVID gloss.
Basically, we still do have the situation where some categories of people are assumed to have contracted COVID-19 in the workplace. They're the people you would anticipate, health professionals and those sorts of frontline services. The reality is, let's just go back to first principles, Jules. Let's just look at this as any other workplace hazard. Let's put appropriate steps in place to manage that risk. And then, claims may or may not arise. there are some protections in place to assist businesses. In New South Wales, for example, there will be those sorts of claims will be accepted from your claims experience if that's something which applies to you. So, I think there is some recognition that this is just a reality. It's here to stay, but let's approach it just as we would any other workplace hazard.
Keeping on the theme of general first principles approaches, in the mental health storm, a lot of mental health claims will be based around the phenomenon of COVID anyway. And so a COVID infection or a debilitating anxiety, stress-related illness that has been born out of the intensity of the pandemic experience, it's an injury. Well, is it an injury? Is it related to the workplace? So on we go. So I think that's how we would deal with it. You can't say it's old news, but it's it is.
I feel like everyone's very familiar with it, unfortunately.
That's right. Well put.
In a way that they perhaps didn't want to be. So we do keep coming back to this idea of psychological injury during this session, I think, Julian, mainly because, it is one of those really front of mind issues for employers when we're talking about managing workers' comp claims. Also, non-work related illnesses as well. But I think the key for psychological injuries, and a couple of things to think about, that insofar as it differs to some extent from physical injuries and conditions, is this idea that we really just need to accept our workers as we find them. So this is this eggshell skull principle, which means basically if you've got an eggshell skull, both from a physical and a psychological perspective, you're more fragile than someone else. That's just who you are and how you are, and you come to my workplace with that vulnerability or that fragility. So it's really just this idea we accept people as they come, as we find them. And then that plays into, how people actually perceive and respond to events that occur in the workplace, and how that then might play into particular vulnerability.
Yeah, if you're injured, you're injured.
That's right.
Regardless of whether you're more likely to be injured. There's an interesting sort of interplay in terms of reasonableness when you're talking about reasonable management action. But this is keep coming back to the mantra, you are not a doctor.
Mm-hmm.
It is just so tempting in relation to psychological injuries for employers, managers, HR directors to play psychologist, to play psychiatrist. A lot of those people are very emotionally intelligent and maybe have a lot of knowledge about those issues, but it won't be enough. Psychological injuries are so difficult to manage because, one, they're difficult to diagnose. Two, the diagnoses usually aren't as black and white. It's not they'll be back in 3 weeks, they'll be back in 6 months. Things can recur perhaps slightly more readily. Things are harder to identify. For instance, a pattern of poor attendance might be the manifestation of psychological injury. Maybe it's not. So it's very difficult to manage. Trust in the evidence. We'll talk about your rights and entitlements to get evidence later in the show. But that's what I would say. Psychological injuries are a real thing. There is an increased awareness of psychological injuries, both from employees and from employers. So we need to get better at managing them and just taking them, as seriously as any other injury. Where's the evidence? What's the diagnosis?
Yep. And I think picking up what you were saying there, Julian, it's important to note that, you might have been as an HR director, as a general manager, whoever you are and whatever role you play in the business, you might have been there, you might have seen exactly what happened that's alleged to have led to the psychological injury occurring. You might have been the one conducting the management action,
yep.
In fact. And quite often what we have people say to us is, well, it just wasn't the way that it's been characterised now by that employee. And what I would say to that is really, to some extent, that doesn't really matter. Yeah. It's the worker's perception of events that's really the key here. And it doesn't need to be, and we've got them in our quotation marks, it's a case quote there on that last dot point. It doesn't need to be rational, reasonable or proportionate for there to potentially be a compensable injury arising. So you did touch there, and we've talked about it throughout the course of the presentation so far, is this idea that everyone has their own role to play, excuse me, in the claims management process, in the risk minimisation and mitigation process from the very outset. And I think when we spoke about, the outcomes, people not coming back to work, the reality is the best outcomes do happen when a worker does come back to work as soon as it is safe for them to do so. And the poorer the outcome, the longer someone's absent from the workplace, the poorer the outcome is likely to be.
And everyone, from my experience at least, everyone needs to be on that train. The employee needs to be genuinely interested in getting better and getting back to work. The rehab providers, the insurer need to do what they need to do. They need to be pushing out emails, making appointments, doing certain things. And lastly, the employer. The employer needs to be interested, invested in the idea of getting this person back to work. Now, some of these things are a no-brainer. I mean, if someone slips and breaks their wrist, everyone kind of is like, hey, well, keen to have you back. Let's get your wrist healed up,
Sure.
And you won't type for the first couple of weeks or whatever it is. Other more long-term injuries, it is more likely that as an employer, they will lose the thread a bit. They'll lose the track. They'll lose the focus on getting this employee back to work. And we will talk a lot about some case examples where exactly that happens.
So I think then it's key for us to recognise everyone has their own role to play, and we need to be a little bit active in making sure that everyone is actually doing what they need to be doing, or what we can reasonably expect them to be doing as stakeholders in the process. One of the key things I've been suggesting to people recently who are struggling, particularly with psychological injuries, is to enlist the support of your rehab provider, because these people or these organisations can be a really handy intermediary between you as the employer and the injured worker, particularly in circumstances where there might be some sensitivity around who's actually contacting or being in touch with the person, and whether or not any of that communication can have a detrimental impact on their prospect of recovery. So they're really important. They also help you discharge your legal obligations, such as developing a return to work plan and assessing suitable duties. And just before we move on that point about suitable duties, one of the things that clients quite often come to us to talk about is the fact that someone perhaps has been certified as being fit to perform some form of suitable duties, whether that's different work to what they'd normally do, whether it's working from home, whether it's for shorter periods of time during the day. And certainly, to the extent that it's possible, we should be endeavouring to facilitate that. And indeed, that's our obligation under the legislation. But it's important to know as well, there are some caveats on that, including that we don't need to create a new role necessarily. Of course, if that's something that you think is in everyone's interests, by all means. But we don't actually need to be creating work where there doesn't already need to be work performed. And the risk of doing that, or the risk of making accommodations that aren't necessarily going to be feasible in the long term, is that we can potentially create an expectation that's a permanent arrangement when that may not actually suit the needs of the business.
The other aspect of that is when, and I find this particularly in smaller businesses where employers perhaps do create a role, go out of their way, go above and beyond in relation to a particular employee returning to work. If the relationship becomes soured, the fact that the employer has gone above and beyond in the past can sort of colour how could they do this to me? We created this role. We didn't need to have him or her back. It can create a sort of a tone and a colour to the whole scenario, which is unhelpful. I should just say, and I think you explained it excellently, Kate, a lot of what we do as employment lawyers is just push employers to think about whether they've really made a proper assessment of the availability of suitable duties. Because it is far too easy to think, oh, well, we don't have anything for them to do, so they can't come back to work. It is in your interest as an employer because you've got legal obligations, to think quite hard about what suitable duties may exist. It's obviously in the interest of the employee, because the sooner they get back on the tools or at the desk or whatever it might be, the more likely they're going to be able to have a productive working life. It's in the end, that's what the whole system is designed to do. The reason why the concept of suitable duties exists is so people can get back into the workplace. Please have a hard think about whether there are suitable duties you could offer to an employee. If you're just making it up, if you're just doing it for the sake of having something, there is a line which you cross, which is counterproductive. But I think suitable duties and really pushing that is a really important thing for employers.
It's a good point, Julian. And I think as well, it's important to draw some distinction around when we're talking about non-work related illnesses and injuries as well.
Yep.
And this expectation, usually on behalf of an employee, that the same obligations attached to an employer in circumstances where we're facing a non-work related illness or injury. And we'll talk a bit about that in a moment. Now, in fact, what a good segue.
Brilliant.
Excuse me. So what are we talking about here? I think we're, let's put aside workers' compensation for a moment, but the same principles largely apply to the management of ill and injured workers generally, whether we're talking about, obligations which are dictated by the workers' compensation legislative scheme or otherwise. So you might even have these circumstances arising where you have had workers' compensation proceedings or a claim on foot that's then been declined or otherwise dispensed with. So what do we need to do, Julian? I think the first point is, as you've said before, be proactive. Be proactive in insisting on factual information, evidence, to actually enable you to make some decisions about what else you need to do.
Yeah, look, the reason why getting energised and proactive about all of these things are important. You look at it in two ways, depending on maybe what kind of person you are. You could look at it in a way is the more energised, proactive you are in pushing, in requiring the employee to provide medical certificates, the more likely it is that they will take ownership of the situation. They will be getting the medical assistance they need. They will more likely, hopefully, return to work. They won't just sit unrehabilitated, unoperated on, or unconvalesced, and hopefully we'll get them back to work. The other way of looking at it is if you actually push for these types of, if you're like a dog with a bone and say, look, we actually just need medical certificates for the time that you're off. Perfectly reasonable and legitimate question or request. You're going to push the employee into a situation where the 6-month, 9-month, 2-year long just fog of injury, absence, nothingness won't occur, because they're either going to be responding to your email and giving you the evidence, or they're not, at which becomes a disciplinary issue and they're not engaging in the process. Again, we come back to it. Every person in the process, admittedly this isn't workers' compensation, but every person in the process needs to be pushing for the same goal. And to the extent that someone doesn't, it kind of ends up being on them.
That's right. And I think it's really important there when we're talking about compliance and we're talking about the provision of information, is to take it one step further and say, what other policy requirements do we have around people who are absent? And specifically who are long-term absent. So, are people complying with their obligations to notify you that they're still off or that they're still incapacitated? Are they giving you those medical certificates? Do those medical certificates actually have enough information in them for you to understand what's going on and what the likely prognosis of the person is going to be? Very
rudely, I'm looking down at the screen because I'm looking at various questions coming in from the audience, and at least some of those questions go to, well, what can we ask for? How much detail do we need? Some of the medical certificates that are going around Australia, and it's been this case for more than 10 years, are appallingly short of detail. They say nothing other than you're unfit for work. Now, that might be sufficient. It might well be sufficient for a short period of time. And when we're talking about actual ill and injured employees, longer period of absences, that's not going to be sufficient.
That's right.
in an ongoing way. So again, we get back to the proactive employer. Do you actually know what the relevant health status of your employee is? Do you know when they might be coming back? Do you know what their injury is, or what the effects of the injury is, and how that might relate to how they're going to perform their work? If you don't know the answers, and to be fair, they're on the slide in the bottom right corner. If you don't know the answers to those questions, you should be working to a point where you're asking those questions, potentially in an IME, or hopefully, potentially just to the employee's treating doctor.
That's right, yeah. And we'll talk a little bit about IMEs and that choice of doctor in the case examples at the end of the presentation, because I think, Julian, one of the things and the questions that are coming through just bears that out, is that employers to some extent feel a little bit disenfranchised when we're talking about this subject. They feel a little bit like they're hamstrung, they can't ask the questions, they can't make those directions. And if nothing else, if they walk away today, if you walk away thinking, well, at least I know what I can ask for and how I can be more active and proactive and what my entitlements are, I think we'll have done a job. But of course, it can never be an entirely good news situation when you're talking to lawyers. And that sort of first stop point on the right-hand side of the slide is the one that we really need to come back to here as well. And these issues arise, and we're not talking about, termination today, and we're not talking about legal risks in this way, but it is important for us to emphasise there are a whole host of legal risks which attach to management of ill and injured workers, or more specifically and usually poor management of ill and injured workers. So you can see there the first one, which is that section 352 temporary absence provisions. That's, of course, a reference to the Fair Work Act. And in the general protections, we find a prohibition on termination of employment within 3 months of the person becoming incapacitated. Important there, I think, just to flag in passing that people are fairly familiar with prohibition on termination when we're talking about workers' compensation. 6 months in New South Wales, 12 months in various other jurisdictions. Just really important to remember, have in the back of your mind, there is a 3-month prohibition when we're talking about non-work related illnesses.
We get a lot of calls to say, look, I know the 6-month rule and I know the 3-month rule, but where do we go from here? I mean, there are further hoops even after that
right,
to jump
absolutely.
through. There will be, even if someone has fallen off a skateboard and it has nothing to do with work, and they have been away, and maybe the 6-month rule is not relevant because it's not workers' comp, but maybe you've jumped through the 3-month rule hoop. Does that give you carte blanche, the get out of jail free card, which you tried to claim earlier on? No, it doesn't. To the extent that they're still able to bring an unfair dismissal claim, if the circumstances of their dismissal on the basis of their skateboarding injury is unfair, if they were going to come back the next week, if you haven't managed the client properly, if you don't know what's happening with them, there's still going to be a legal risk. So we never said this would be easy, and it's not, quite frankly, even when it's a non-work related injury. But I think, again, we'll just keep hammering the point. It's better to do something.
That's right.
It's better to be asking the questions, to be asking for the information, and to be doing something than to be doing nothing.
That's right, Julian. And you've mentioned unfair dismissal there, which of course I think everyone's fairly familiar with. It is the bad guy when we're talking about termination of employment. Also really important to note there that general protections adverse action extends beyond the section 352 temporary absence protection. And, we might be ending up in a circumstance where someone's alleging that they've been discriminated against because of a disability, or for taking their personal leave, which is, of course, a workplace right that all employees do have. So, yes, I think we get very gung-ho on emphasising the importance of taking action. It is important as well to take a step back sometimes and go, okay, where do we want to end up, and what's the safest way to head there? So I think this slide, just sort of summarises some of the themes that we've spoken about up to this point in time, talking about employees actually having obligations themselves as well.
Yep.
We talk a lot about what the employer needs to do, and I know a lot of people get very tired of hearing all about the obligations which flow from their status as an employer. But the reality is employees do have rights and obligations, and, we are entitled to expect that they will comply with those. The first one, as you said before, Julian, is about, actually providing medical certificates and medical evidence. I know that's something that people do struggle with. Also, the further on from that is attending a medical examination if and when it's deemed appropriate and reasonable by the employer. Complying with policies and procedures, of course, whether or not it's a leave issue or a workplace injury issue, anything else, we do have that right and expectation that our employees will comply.
If it all goes south and it ends up in a tribunal somewhere, the first question that will be asked will be, well, what did the employer do? What did the employer ask for? What did the employer provide? What did the employer make decisions about? If you can tick those boxes as an employer, then the focus goes to the employee.
That's right.
And as I said before, depending on how you look at the world, it puts an emphasis and onus on the employee to do something to get back to work, or it puts the employee in focus about the emails they didn't respond to, or the certificates they didn't provide, or perhaps the medical appointments that they didn't attend. And that's a much easier case to run than one where there's an absence of anything.
Entirely. I think as well, and it's worth emphasising here, though we will come back to it later on, is this idea of the humongous importance of actively communicating with people, even when they're on periods of extended leave. And as I said, we'll come back to why that's super important and particularly important in the current context in a moment. But I think that's just, again, a good reminder, even if someone is, very unwell, even if it's a serious psychological injury, which might otherwise be, or illness, which might otherwise prompt you to think, perhaps we'll just leave that person alone to focus on their recovery. That approach may not be the best in the circumstances, and you really need to think carefully about other things we should be doing even in the meantime.
I might just, the chat box has gone all a current affair, naming and shaming dodgy doctors. But some of the questions are about, well, look, we think there's a fraudulent doctor being set up. How can you check doctor certificate? We think it's dodgy, so on and so forth. Again, and putting ourselves back in we've got to the tribunal and the focus is on us. What did the employer do? There are obvious basic one-on-one things that you can do to background to check whether a certificate that you've received is legitimate. Does the doctor exist? Does the practice exist? It's certainly not unheard of that people might ring the phone number on the medical certificates to ascertain whether that particular person exists. Obviously, what's in the information could be subject to a second opinion in the form of an IME. But the other aspect, which I think sort of has to frame all of these things, and we keep coming back to this as employment lawyers in all of these webinars, what's reasonable? What's a reasonable thing to accept? What's a reasonable thing to do? Certainly, it is not the plight of the employer simply to accept, well, he's got a piece of paper that has, doctor on it, and therefore I can't do anything. You can make your own inquiries, and it'll be subject to a question of reasonableness. There isn't any one size fits all answer to that, unfortunately.
No.
Someone takes a day off and they put a very non-detailed certificate in. It might be reasonable for them to rely on that. Won't cut the mustard if they're off for months at a time.
That's right. So I think it's a good time then, Julian, to move into some of our case studies. We could talk at length. There's innumerate almost case studies we could pick, decisions of various courts and tribunals.
We could do a webinar on each of these cases for an hour.
We could. We won't. But the first one, and coming back to your entitlement or your rights as an employer. This first one is just our classic,
Thomson.
Summary. Wrong spelling.
Sounds a bit suspicious. Keep going.
It's the case which says basically we have certain rights and entitlements as the employer, and in particular you have the right to pick the doctor that you want to send someone to, that you want to get some information from. We kind of extrapolate out the principles from this case to say, well, firstly, you have a common law right, even if you don't have an express right in a policy or procedure or enterprise agreement, to send someone for an IME in certain circumstances, as Julian said. And secondly, you have the right to say, well, I'm not really satisfied with the medical evidence that's coming back from your dodgy GP. I'd like to send you to someone else, perhaps someone who has a specialty in that area. Or even if it's a complex issue, perhaps we think about an occupational physician or someone who's really got some background in, what kinds of questions do we need answered to enable this person to either come back to work safely or for the employer to make those key decisions.
So the odd part about this case, which I think it's in the poker machine business.
That's right, IGT, yes.
So the odd part about this case is I think the injured employee actually had a back injury, but that sort of manifested in this sort of course of history where increasingly poor attendance, some interesting sort of medical evidence that was being dredged up, and the employer made the determination, well, actually, we need an assessment of this person's psychiatric health so that we can fulfill our requirements under our work health and safety obligations. And the counter to that was, well, it's got nothing to do with my back. Like, I'm not going to go to an IME. I'm not going to go to a psychiatrist. The decision on its face is very, very clear. Read the slide. If it's reasonable, and in the last paragraph, it said, in my opinion, it was reasonable. So that's what we need, and probably necessary for the respondent to find out more about the applicant's condition. If you're going to act reasonably, you're going to have an entitlement.
And I think just before we move on, a really good time to pause and just consider that word reasonable in this context in a little bit more detail, Julian. And I think, again, no one-size-fits-all approach will be the answer here, which is that, in some circumstances it will be entirely appropriate where you've got a GP who's very familiar with someone's condition, whether it's, work-related, workers' compensation or otherwise, to provide you with some more detailed medical evidence above and beyond what we see in a standard certificate. That might be appropriate, that might be eminently reasonable.
And on that case, it might be completely OTT to go, actually, no, you need to go to a full psychiatric assessment. It might be beyond the bounds of reasonableness. It just depends on the case.
That's right. And I know people get very frustrated with lawyers answering, well, it depends. But
we'll help you if you call us. I mean, that is actually true.
That's right.
We do a lot of this work. These are part of ironic given my comments about doctors. This is not science in some respects. It's a careful balancing process. There's a sense to this where you need to take a look at the situation and make a call. As we keep going back to, it's important for employers to be making calls, to be making decisions, to be actually moving these things on. And so, yeah, it's difficult, but there's people you can talk to.
Yeah. And I think when it comes to assessing, okay, where do we go from here? What is reasonable? That's one of those junctures at which you might want to consider whether you give us a call. Here is our most recent of the cases, Julian, and I think a very unfortunate set of circumstances.
It's difficult. I find it difficult to discuss ill and injured workers' cases because obviously there's been an injury that, like, a human being has been adversely affected. So this has received an extraordinary amount of publicity, at least in terms of the publicity we read, the IR Nerd Weekly. But yes, it's a Sydney Water case. A very unfortunate employee was featured in a risque promotional material. I'm not sure how that happened. To be honest, I'm sure that must be there must have come out somewhere as to who made the decision, who thought that was a good idea to put that byline under an employee's photo without her consent. But anyway, it resulted in a psychological injury. Can you take the story up there, Kate?
I can, yeah. So as a result of what had happened, this worker was absent on workers' compensation initially, and then once that period of time elapsed, she continued to be absent, was still very unwell by all accounts, and was unable to return to work.
She was running some cases, wasn't she, as well?
Yes, and again, picking up IR Nerds Weekly, if you are inclined to read about the history of this matter, there is a lot of publicity around some of these other actions that this employee decided to take in relation to what had happened to her. So we have, complaints to the Human Rights Commission and the ADB alleging sexual harassment and sex discrimination. So putting all of that aside, for current purposes, she was ill.
Yep.
She was injured. She was absent from work, and then latterly on a period of unpaid leave. So for a period of 3 years, Julian, she was actually absent from work on unpaid leave. She then made a decision to resign from her employment at the end of 2020. And then interestingly, and I think, again, the IR nerds amongst us, kudos to the creativity of deciding to run the claim in this manner, but then decided to, following her resignation, run a general protections claim involving dismissal, alleging that she had been subject to adverse action after complaining about the poster. The interesting thing here, of course, is Sydney Water came back and said, well, hang on a second, she resigned from her employment. She wasn't terminated.
We didn't do anything.
We didn't do anything. So on that basis, she shouldn't be entitled to bring an a general protections claim involving dismissal. The very nature of the claim involves that dismissal has occurred at the initiative of the employer. So at first instance, Deputy President Beaumont actually found the employee had been forced to resign, having regard to a number of the features of the incident. But importantly for current purposes, the evident void of communication between the employee and her employer over about a 3-year period during the time that she was on unpaid leave. So here's a bit of an extract from the decision. So unsurprisingly, Sydney Water did appeal. It went to a full bench of the Fair Work Commission. Interesting, I think, few features coming out of this little quotation here, which is the emphasis that was put on the employer to actually, reach out, do something, actively manage the situation, and the implications that had for how the employment actually ended up ceasing.
There's an acknowledgement there, and I think it's fair that it's a difficult circumstance. Like it is, ill and injured employees, difficult scenario, particularly difficult if the injury occurs through an act of the employer, which creates a lot of publicity, particularly even more difficult if there's some litigation, maybe there's a workers' compensation claim or some other claim. But it doesn't entitle an employer merely to pull up stumps, cancel, turn off their computer and, well, let's just wait this one out. That's not how the law works. The law, as I said before, when you get to the tribunal, the first question will be, well, what did the employer do? And if the answer is nothing for 3 years, it's going to be very, very difficult to justify that absence of anything. We occasionally, I must say, 3 years is actually not
the longest.
It's certainly not unheard of. And look, and it's certainly not uncommon at all for an employer to say, look, this whole situation has got nuclear. We don't want to do anything. We don't want to antagonise. That, you can take that position, but it's not a safe position. There might not be any perfect answer, but it's usually not wait 3 years.
That's right. So, as I said, the decision went on appeal, unsurprisingly, because it was a somewhat controversial first instance decision by the Deputy President to say, well, yes, actually, it was Sydney Water's inaction that ultimately forced the employee's hand. So what does that actually mean? On appeal, the full bench upheld the decision at first instance. So they basically said, yep, it was open to the Deputy President to make that finding with respect to the end of the employment, and therefore the employee was entitled to run the claim in the way she had brought it. So what does that mean? And I think, we've alluded to this a number of times. Basically, don't just set and forget.
Have a plan.
Have a plan.
Have a follow it up. If you've got, unfortunately, there are many organisations that have a list of long-term injured employees. What is the status of each of those employees? When was the last time you contacted? Who is meant to be providing the next step? What certificate are you waiting for? On and on it goes. The prolonged silence is not a sound strategy.
And I think just before we move on, really important to just emphasise the fact there that someone needs to do something. Common misconception that particularly where workers' compensation is still involved, that the employment will somehow cease at some point in time with no action being taken by either party. That's just not the case. And, either the employer needs to make a decision that the employee is not likely to return to work and it's unreasonable to consider any adjustments that might need to be made for that to occur, or the employee needs to resign.
Noting the time, we probably don't have enough time to talk about abandonment of employment issues. The answer is probably not abandonment of employment. If that's what you're thinking out there, it's usually not. So let's move on.
So before we end, a couple of, I suppose, cautionary tales, Julian, about working from home arrangements. And this is slightly ancillary to what we were talking about through most of the presentation, but I think really important to talk about. But firstly, are we allowing people to work from home? Are we managing our risk appropriately when they are doing so? And a common question that's coming up at the moment as well is, well, if we've got someone who's ill or injured, can we allow them to work from home instead of taking personal leave? And so this first one is a really awful set of circumstances. You can see it there on the screen. We won't labour the point, I think. The important thing to note here, and the takeaway message we take from this case, is it's really important to recognise that the bounds of the workplace and that traditional understanding that we have don't just stop at your physical premises. You actually do need to have some recognition and consideration of, if someone's working from home, are they safe? Are they in a safe environment at home? And if not, or if we're concerned, have we appropriately managed that risk?
The other less important than employee safety aspect of this case, which I think is interesting, is that the minutiae that the tribunal, or the court rather, went into to determine whether it was in the workplace. Where were the files located, for example? What time did the employer usually start work? How was work arranged? I'm very sure that a lot of employers in Australia currently do not know the working from home patterns, arrangements, how offices are set up in their employees' home offices, even though those home offices have been operating for at least 2 years. These are pieces of information that it would benefit employers to know. And if you do need to provide restrictions or provide directions or rules about how people are setting up their work office or how people are working from home, you should do that, because if something, and this is an extreme and absolutely devastating example, but if an incident does happen, those are the types of things that will be relevant to anything that arises.
That's right. So just to finish off on our work from home cautionary tale segment of the presentation, Julian, is this Telstra case. And it's now 10 years old, but when it came out, it was, front page Daily Telegraph news, current affair, I think you mentioned before.
Can I give you the Courier Mail headline?
Absolutely.
A slip and a fall and the employer pays for it all.
Oh, I'd love a bit of a rhyme in a serious news headline. Excuse me. I think this was before, well, it certainly was before working from home became a real actual thing that a lot of people needed to do and actually, became quite comfortable with doing. But what we have here is a circumstance where a lady or an employee was working from home with the authorisation of her employer. In the first instance, she slipped and fell down the stairs. On this occasion, she was unwell. She was suffering from a cold or, some kind of respiratory virus, as we are all very familiar with nowadays. She was going downstairs to get some cough medicine to manage her symptoms to enable her to continue working. And this is where this becomes a bit of a cautionary. If we've got someone who's sick, should we be enforcing them taking personal leave?
Oh, I understand now what you're talking about. No, I get that.
Yeah.
She's getting the cough medicine.
She's getting the cough medicine.
Sorry, I'm slow.
Yeah, so getting the cough medicine so she could actually continue on with her working day, slipped and fell. And because she was, doing something which was required to enable her to continue working, that first slip and fall was a compensable injury.
But that wasn't the only slip and fall.
That's
and
right,
it wasn't
Jules.
the only employer direction. The employer had directed her to ensure that she locks the downstairs door because there'd been some thievery in the vicinity, in the neighbourhood, and obviously the employer equipment was upstairs. She's wearing socks. She goes down to lock the door. She falls again.
Yes, so again, another fall, another compensable injury, and again, you know, a really, I think, good illustration of the risks and issues that can attach to not knowing what people are doing while they're working from home, not having appropriate risk minimisation strategies in place.
And directions about what people are doing in their
Correct.
house, in their homes, are going to have consequences.
Yeah, that's right. So what do we do? We've spent a good hour now telling everyone how terrible things are.
I think we've covered most of this, to be fair, Kate. I mean, I think we need to revisit our risk assessment, our management frameworks. If they've been sitting in a drawer for the last 3 years while you've been dealing with the worst pandemic we've had in a century, we need to take them out again.
Yep.
Reviewing existing policies. If you don't have a work from home policy now or checklist, you should certainly get one. Giving people responsibilities for active management of workers' compensation claims is really important, particularly in an environment where people might, where the person sitting in that hot seat might change. Good systems mean a good process. If you don't have good systems, as people come and go from that particular position, people will be left out in the cold, and unspoken to, uncontacted for the years that we've talked about. And look, investment, I mean, it's about, we talked about the mental health storm. There are things employers can do to benefit the mental health of their employees. There are things employers can do to benefit the physical health of their employees. Yes, it costs money, but then again, probably not my position to say, but there's certainly investments that can bear fruit.
Absolutely. And, you know, sometimes you need to spend some money to save some money, and this is no better example of that.
Amen.
So how can we help? Hopefully we've given you some indication of that during the course of the presentation. A lot of what we do and a lot of what we can help with is the review and creation of those documents that Julian just mentioned. We're also able to assist with training of your staff, management training as well. We do have an upcoming Managing Ill and Injured Workers online training course, Wednesday the 24th of August. I do have to have full disclosure, I am delivering that course.
Perfect.
So if you are sick of hearing from me, you know, exercise your right not to sign up for that course. We do also have more in our series of webinars coming up next month. I believe it's a focus on managing employee misconduct, which if you've got some ideas coming out of the themes from this presentation, you might need to tune in for that one to work out how to close that loop as well. So thanks very much, Julian. It was really great to chat to you about these issues, and thanks everyone for joining us. We hope you found this informative, and of course, if you've got any questions, please don't hesitate to reach out.
See you later.